Well, I gotta grab the petition, but so I gotta come in and get it. But yeah, you can go ahead and call and see if
Okay.
he's available.
Yeah, Paul Stout here.
Good afternoon. This is CV 2024-022841. This is the matter of Paul Stout and Vladimir Gadget. Sir, would you raise your right hand and be sworn?
Yes, sir.
You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You're seeking an injunction against a Paul Gadget. Can you tell me who Paul Gadget is?
No, I'm sorry, Your Honor. It's Vlad, V-L-A-D, Vladimir Gadget. I'm Paul Stout.
I'm sorry. Did I say Paul? I'm sorry. Vladimir Gadget.
My name
Can you tell me who he is?
He's who I'm filing an injunction against for harassment.
Okay. Can you tell me who? How are you connected in any way? Do you know him?
I do not know him. My fiance is Rachel Mitchell, the county attorney, which I'm sure you've heard of her name. And so I put this in a very long, I'm not in the legal business and I apologize, but I did the best I could researching this, and it's rather long and single-spaced, but I tried to give you a synopsis, up front.
I know. I know. I've read your petition. I just have to, under the statute, I have to actually interview you, and you have to tell me about the allegations. But the first first issue I have with your petition is that you're telling me you were born March 1st of 2024, and I think I need to correct that.
Okay, what did I say that I apologize? It's March 1st,
Go ahead.
It's March 1st, 1961.
All right, let me correct that.
I apologize.
That's okay. It just, let's see. I'm sorry, 1963?
March 1st, 1961, Your Honor.
Oh, 61. Thank you.
Yes, sir.
All right. Now, you've listed a number of things, and it doesn't have to be exhaustive, but I have to have you testify to me as to what's taken place with respect to Mr. Gadget, which lets you believe you need an injunction against harassment, starting with July 7th.
Okay. Yes, I do not know Mr. Gadget personally. I do know that on various Twitter, various social media platforms. He had made some comments negative comments about my fiance. This is how I learned of him, and I asked, who is this person? And so then I replied on Twitter asking him, like, who are you? Are you the person who was suspended from the bar and so forth? And then from that point on, he has attacked me for months and harassed me and harassed my fiance for months.
Okay. You say that he's posted that he wanted to meet up with you and fight?
More than once, Your Honor, and I have, since that time, even before then, because of that challenge, and I'm out with Rachel quite often at different social events and, in restaurants and different things, both of us have been extremely scared and looking over our shoulders because this person poses what we feel is just significant harassment to our lives, change both of our lives like you would not believe.
And looks
May
like
I add one more thing, Your Honor?
Go ahead.
Yes, I just wanted to say, Your Honor, that I don't have protection 24/7, neither, and in terms of security, and same with Rachel Mitchell. And as a result, in our household, we're in the same household, we've had to actually enhance security because of that fact that we don't have 24/7 security. So, yeah, we're very concerned and very harassed, both of us actually.
Okay. And I do have to go over some of these allegations. He has posted implications, at least, that you are a child molester, correct? It looks like.
There's an accusation, yes. A pedophile, and I owned a children's theater years ago, and the public posts that he has made repetitively, not just once, has basically said that, if Rachel's fiance is a convicted pedophile and she hid that from the public, do we really want her as our top prosecutor? All of this was going on during the election, the primary election, and it impacted my reputation. He went on on 725. He also went on to say, does Paul have a thing for young children? Why Mitchell is hiding her engagement to Stout, because we're engaged. So repeatedly saying that I'm interested in little kids, and in some cases, over 100,000 people have viewed this on social media.
And in that post, there was a post where he actually used your picture. Is that correct?
Yes, Your Honor. He used on Twitter, on X, formerly Twitter, he put a picture of me and Rachel when she was sworn in as county attorney 2 years ago, and he used a separate, smaller picture of my face. And just for some reference, Your Honor, X suspended his account for weeks for impersonation. They found that he had been impersonating me, and that further damaged my reputation. But more importantly, it was just a barrage and continued harassment from this man, both of us, just daily, multitude of times a day. What I've given you here, sir, is more than anyone should have to read, but this is just the tip of the iceberg of what he has done to myself and Rachel on a daily basis. Nonstop harassment.
He contacted your former employer, the Department of Public Safety, on June 7th?
The Department of Child Safety, Your Honor.
Yes.
I'm sorry, I thought you said public safety. It's actually DCS, Department
Okay.
of
Child safety.
DCS. Yes, sir. He had he and Rachel Alexander, who is also she's a debarred attorney. He went to a former employer, a state of Arizona Department of Child Safety, trying to warn them about me. It was published in an online publication by Rachel Alexander, which is called WND. It's an online publication that's read by hundreds of thousands of people. And in that article, basically, they mention that he was trying to essentially get me fired, which is false claims and so forth. And so I did not work there for at least 7 years, but still the intent was to get the employer to fire me. And they wouldn't answer any questions for him, and so he was posting more additional things to harass me that I didn't include everything in here. I don't want to give you 10 pages.
Well, I appreciate that, but
I felt bad, Your Honor. I felt bad with the single spacing, and I really feel bad that you have to have all of this. But I just don't know how else to convey it unless I give you some kind of context here.
No, I understand, and all of them are important, and
but again, I apologize because you've got other things in your life than have to read, a long book, and so I do apologize if I've impositioned you in any way.
Not at all. You don't need to apologize. That's what we're here for. This is our job. He posted a police report talking about a burglary at a business in this is very.
Can you tell me what? Sir, can you tell me Your Honor? Tell me the date.
August 7th. He posted a portion of a police report from 2001 that involved a burglary for Paul worked at just like Al Bundy. Tell me about that one.
He said, I worked at, my ex-wife had a heart attack, and I lived at Anthem. And I was working part-time because the state of Arizona wouldn't let me work 410s, and I was trying to make extra money to help because my wife had a major heart attack at 38. And so there was a break-in, and I closed with another employee the night before. We threw the keys in the safe, and then there's a self-locking door in the back. You leave, but you can't get back in. And he inferred that was I part of this, robbery. And so he published that also on social media, saying that, isn't it interesting, essentially, that, I was there the night before. So he's painted this picture of me and further harassment that this man is just after me, after me every single day. He's posting several things about myself and Rachel Mitchell, just nonstop harassment. I had nothing to do with this, and he's bringing stuff up from 2001. He says he sounds suspicious as hell, don't it? Pardon my language, but Sergeant Penzone and everyone that was there who took the police report, there was nothing to it. I just felt I was with my manager, but then he asks everybody out there, sounds suspicious, doesn't it?
Okay. You understand, we have to be real careful when we're talking about some of the social media postings and interfering with people's right to post. And I think, common posts are probably, not necessarily what we would consider harassment. But I think in this case, it appears to be communication which is designed and
Your Honor, may I add
designed
something?
to harass. Go ahead. Yes.
Your Honor, I want to be respectful of your time, and I'm a novice in this, but I spent a lot of time trying to build my case here, and I appreciate you listening. I have a synopsis as well before, if the court will allow me, before we go. But I wanted to say to you that the other day, and I put this as well in the petition, he is impersonating me with another account called Paul Stout. I want to let you know that the FBI is actively investigating this case and has been for the last few weeks. Why I bring that up is because he alarmed the Manhattan DA, Alvin Bragg, that I had wished that a judge in Manhattan that had prosecuted the Donald Trump, that I was hoping for his electrocution. When this happened, he sent this to the FBI, and he sent this to the Manhattan DA, and Rachel Mitchell intervened on my behalf. I was scared the whole day that I was going to be arrested by the FBI. I was so scared. I was making arrangements for my dog and stuff like that, and I didn't know what to do, and I was really a nervous wreck. But bottom line is that she had informed the FBI in Arizona, and she had informed the DA at Alvin Bragg's office that this Paul Stout was not me, and it had nothing whatsoever to do with her.
Wow.
This was the latest thing that he's done, and I've been in fear like every single day that someone's going to come and arrest me, or I have to look over my back that he's going to be here. He's a former Marine, and trying to engage me in fights. I'm nervous. I'm very nervous, and so is Rachel. We're very, very nervous and scared. And in fact, I will say to you that the FBI has concluded that if this injunction is in fact, which I believe it should be, but that's your decision, of course, Your Honor, that the FBI will be accompanying an ex-FBI process server, very well known. They have advised the process server that they want to go with them to serve the injunction. And they stand ready today to do that.
All right. I'm putting in some other orders here.
I did have some case law too, but like Judge Judy usually says, don't bring stuff up if you don't need to.
Good point. No, I did see the those and appreciate them, and
Thank you, sir.
I am
Remember, I failed my LSAT when I was a young kid in Queens. I wanted to be a lawyer, but I failed my LSAT because my friend that was an engineer went to Hofstra Law eventually, but he was an engineer, and he said my analytical skills are much better than an economist. And I said, well, let's do the LSAT and no studying, okay? And he passed, went to Hofstra, and I failed.
Oh, well. Well, you could try again.
So, but I did put a lot of work in this on these cases.
And I am going to
And I don't want to interrupt you, sir, but I do have a couple questions at your when it's convenient for you.
certainly.
I'm afraid he has guns. He's a former Marine. I'm afraid that he has guns, and I have also put that in the petition for you to consider, Your Honor.
All right. Hold on just a sec. All right. Let's see. All right. Go ahead. You had some questions?
No, sir. I just wanted to know, I don't know how the process works. And thank you very much for granting this. It really is, I can't tell you how much I appreciate you for granting this.
All right.
It's been a nightmare, sir. It's been a nightmare, sir. Nightmare.
I understand.
I don't know the process. Could you tell me how the process works in terms of, like, for process servers, so I know myself?
Yes.
Do they wait to be notified? Or?
I have to give you the boilerplate advisement now.
Okay.
And so based on the testimony and the petition, I do find reasonable evidence of harassment of the plaintiff by the defendant such that greater irreparable harm would result if this injunction were not granted. He's to have no contact with plaintiff other than through legal counsel, legal process, or with permission of the court. He's not to come to the residence, which is a protected address. He is do find he represents a credible threat to the physical safety of the plaintiff, and is not to may inflict bodily injury or death. He's not to possess, receive, or purchase firearms or ammunition. And I have revised your other orders request somewhat. I have said this defendant shall not post personal attacks on plaintiff which do not convey a message of public interest and which contain lewd, profane, obscene remarks. Defendant may comment civilly on plaintiff's ideas.
The question I have, Your Honor, would be for the things that he has on YouTube. I mean, he's claiming that I have an abusive history, and he has a picture of Rachel and I, like, holding the Bible. He has quite a few things on different platforms, Facebook as well. His entire Facebook page is devoted to me only. Everything that he's posted is only about me. Do you have the authority to have him remove those posts? I've tried and have some.
Unfortunately, I don't believe I do in connection with this process. An injunction against harassment prohibits communication from the defendant with the plaintiff or contact. And in this case, I believe that the communication that has been leveled is designed to communicate to you. But there's nothing in injunctions against harassment which allows for affirmative injunctive relief, that being ordering somebody to do something other than not communicate or have contact with you. I don't believe it gives me the authority to order affirmative injunctive relief. I think that has to be done. Go ahead.
May I respond, Your Honor?
Sure.
On my with Whitaker versus Warden, ARS 12-1809. In Whitaker versus Warden, it said Whitaker got an injunction prohibiting harassment because Warden had made over 100 social media posts personally attacking him. And as it goes down further in that case, it says ruling, the courts can stop this because a person should not have to endure repeated frightening, dangerous, or otherwise alarming and intrusive personal conduct that serves no legitimate purpose. And then lastly, if I may continue, it says First Amendment, the injunction did not violate the First Amendment because it prohibits communications that are lewd, obscene, profane, or which are personal attacks and do not convey a message of public interest or a matter of public concern. Wardens still can comment on Mr. Whitaker's ideas. And then lastly, it's a directed Snyder, let's see here. And then on this other one that I had as part of 1809, it basically, let's see here. Oh, yes. Directed, and this is Snyder now, the Snyder case, posted videos on social media referencing the victim and the order of protection. The court found that but for Snyder posting the videos, their content would not have been communicated to the victim, Snyder, paragraph 16. So I guess what I'm saying in my synopsis is that I feel that this does give you the authority to, I believe this gives you the authority to direct him to not post any more social media harassment
And that's what I've ordered.
Oh, sorry.
That's what I've ordered. I put in other orders. I say defendant shall not post personal attacks on the plaintiff which do not convey a message of public interest or which contain lewd, profane, or obscene remarks. And defendant may come.
Them, Your Honor,
what's that?
If he has already posted them, Your Honor, your feeling is that you do not have the authority to tell him to remove those posts that are already exist. Okay.
Yes, I don't believe in injunctive against her, and I don't think that I'm not talking about the First Amendment here, or that he has a right to have those. I'm talking more simply about the injunctive against harassment statute and what it gives authority for me to order in this process. And I don't believe this process allows me to order affirmative injunctive relief, which would order somebody to do something other than not have contact or not have communication. So I feel I can order him not to post harassing communication, but I don't believe I have any authority in this process to order affirmative relief, which would order him to remove things. And I understand that seems like a silly distinction, but I don't believe there's anything in the statute which gives me the authority to do that. I think that would have to be done in a civil case. Go ahead.
My final point, Your Honor.
Sure.
So based on ARS 12-1809 and Criminal Law 13-2921, they both have similar definitions of the harassment, and I get all of that. I was just wanting to make a final point. That it says that conduct, and it says directed at a specific person that would cause a reasonable person to be seriously alarmed, annoyed, or harassed, and the conduct, in fact, seriously alarms, annoys, or harasses the person and serves no legitimate purpose. My interpretation of that means that it doesn't matter if he posts it now and into the future, but it also would be conduct that he has exhibited that was directed at me and has already posted that serves the same purpose as if he were to do that now and into the future.
All right.
So the conduct doesn't say past or present. It just says any conduct that's directed at me. It doesn't say past or future. It just says any.
Well, I agree. It's harassing behavior. Well, and what he did was harassing behavior. But I don't feel that this statute that I'm functioning under, or the rules of protective order procedure, give me any authority to order affirmative relief. I don't think.
Thank you, Your Honor.
I don't, and I'm only talking about the statute. I'm not talking about whether it is or is not protected behavior. I'm talking about whether or not. I don't think that this statute, which is 133601, or the rules on injunctive relief, injunctive harassment relief, give me the authority to take affirmative relief, such as ordering somebody to do something other than not have contact or not communicate. So I don't feel I can order that. I can order him not to post, which I am doing in other orders, but I don't feel I have that authority to order him to unpost, if you will.
Would you mind if I have 30 seconds? I have a question into a legal person that I said that some of the stuff is above my head, but I would like 30 seconds or so, if you wouldn't mind, for me to have a response to your response. Would that be okay, sir?
Go ahead.
Thank you, sir. Okay, I have the question in. That's all I have, actually. I'm just waiting for just a reply to you. Fully respect your position. I just wanted to make sure that I covered this last comment in reply to you. Thank you.
All right. The order is valid for 1 year from the date it's served on the defendant. It must be served in order to be in effect. If at any time during the year he requests a hearing, we would come back to court within 10 days. A hearing would be held. You, as the plaintiff, have the burden of showing by a preponderance of the evidence that the order needs to remain in place. If he does approach you or continues to harass you, you should contact law enforcement. If you change your contact information, address, or phone number, please update it with the clerk of the court so they'll know how to get a hold of you.
Yes, sir.
All right. We're going to send you a copy of the order by email.
By email. Thank you so much, Your Honor. I really appreciate your time and your allowing me to speak so nicely. You're great. Thank you so much.
Well, thank you. Have a great day.
You too, sir. Bye-bye.